Hey, I just wanted to take a few minutes to go over some frequently asked questions that affect the question around wills and trusts and estate planning, and kind of outline for you our process that we engage in at Irvine Legal in order to help individuals and business owners and families navigate the various steps in that process. So the first question that often comes up is, what in the heck is a will? And do I need to have one? And if I do, what's going to happen to my family if I pass away at some point? And the reality is, a will, by definition, does not become legally effective until you pass away. And so, because of that distinction, a lot of times, almost always, a will has to go through a small court process called probate. And this is the probate process is the step in the court where everybody gets worried, because this is often where individuals and family members and potential beneficiaries are notified of court proceedings and of an estate being opened. And this is where people come out of the woodworks with claims to try to challenge either your instructions, or if you didn't even have a will, just the default instructions. This can really consume a whole lot of time and energy and financial cost as well. I don't recommend just having a will by itself, but obviously something is better than nothing. For most everybody that has a value of their estate more than $100,000, which usually means you at least have a house or maybe a retirement account of some kind, then I would always recommend having some kind of a trust package. Now, I'm not going to get into all the various types of trusts that exist, but suffice it to say there are dozens, if not hundreds, of different kinds of trusts that exist. There are ones that will protect your assets. There are ones that will make sure special needs are met. There are ones you can use for Medicaid planning. There are ones you can use to hold insurance. There are ones you can use to hold real estate. There are ones you can use for charities, for the sale of a business to avoid taxes. There are tons and tons of trusts out there. The most common type that I recommend, and what I consider step one of any family or any business or any individual's estate planning, is what I call a revocable or a living trust. And this kind of trust is something that we set up while you're alive. We fund it with at least one asset in order to avoid the probate process. And usually we combine the power of attorney, healthcare directives, and related ancillary documents that would go with these kinds of plans. And so that's step one. I'd say everybody, I don't care, rich or poor, young or old, everybody should have some kind of a trust, a revocable living trust put in place. And then beyond that, depending on your circumstances, we might go into one of three further steps. Step two would be to evaluate your business, if you own a business, and how that business in particular might be handled in the event of your passing away or the other owners. There are a number of factors to consider in that. And so there's definitely not a one size fits all approach. This is very customized. Step three would be to look at your estate and look at the assets of your estate, and to consider whether we should implement and put in place certain, I guess, protections is the best way to say it, but certain tools that will allow you to keep those assets safe, to keep them protected. A lot of people confuse the family or the revocable or the living trust and think that it provides asset protection. Well, it does not. By definition, it does not. Anyway, not everybody needs that, but a lot of people will benefit from that kind of a tool, or at least that kind of a discussion. And then once that's done, step four, we would explore whether or not the size of your estate, meaning the financial value of your estate, is going to trigger certain tax thresholds that either the state or the federal government is going to assess certain tax penalties or assessments on the size of the estate. And if that's the case, we like to be proactive about putting in place other tools and other vehicles in order to make sure that the tax planning for your estate is handled. Now, again, not everybody needs all four of those steps, but 100% if you have a will or if you don't have anything at all, your family's going to court. If you want to avoid that, my recommendation is we start with step one, the family revocable living trust. And then depending on circumstances, we analyze the need and the potential options for step two of how to deal with your business in your estate. Step three, how to actually look at the asset protection available to you. And then step four, how to strategize to limit the kinds of taxes that will be assessed on the value of your estate. Bottom line, these rules change, these thresholds and the specific numbers change. And so I always offer free consults to discuss these. Everybody's situation is different, but happy to be a resource. Obviously, you know how to get a hold of us, and I look forward to speaking with and helping you and your family and your business navigate these ups and downs and these question marks successfully.